Welcome to Rebel Chaser. My name is Gail, and I've got two videos for you, and they're both from Judge Wolf's court. So I'll let you guys watch, and I'll talk to you at the end.
Lastly, we had Tara Lynn Bailey versus David Mitchell Bailey Jr.
Tara Bailey, we have 3 motions pending today.
You want to have your client have a seat? I have the first one is a motion to dismiss the father's petition as moot.
Yes, Your Honor, we can start there. Just a nature of background for the court. This matter's been pending since 2019. We have a trial set in 2 days in front of Your Honor, November 5th, day after tomorrow. There are 3 petitions that are pending for trial. It's the father's petition for to modify child support and to terminate or reduce alimony, mother's petition for civil contempt for enforcement of the final decree of divorce for attorney's fees and costs, and then father's petition to enforce the parenting plan. Starting with the motion to dismiss father's petition as moot, as I said, one of the petitions is to enforce the father's parenting plan, to enforce the parenting plan, but there are no more minor children in this case, Your Honor. All the minor children have emancipated. The last one graduated from high school this past May, so child support has expired, and we just have to figure out how much it is. But at this point, we'd argue that that petition is moot, and there is no more. There's no longer a parenting plan for the court to enforce. Should I go on to the next motion, Your Honor?
You may.
Okay. The other motion is the motion to enter child support worksheets nunc pro tunc. So as you'll recall, Your Honor previously referred us to a special master hearing to resolve some of the issues that have been pending. We had the hearing. Both parties filed exceptions to the special master's findings. We had a hearing on those exceptions, and on February 12th, 2024, Your Honor entered an order which ruled on each party's objections and modified the findings of the special master. This was, Your Honor, modified some of the variables that were used to calculate father's child support obligation from February 2019 to June 2021. However, Your Honor's order did not include the new calculations or the child support worksheets that actually stated what father's child support obligations would be during this time. So for the order to be complete for that time period, we need child support worksheets to be entered that take the variables from the special master's findings and the ones that you modified and put that into the court's order. There are no factual issues left to be heard for those child support worksheets for that time period. It's just the actual calculations. And the first exhibit I'd like to enter, Your Honor, here's the child support worksheets that I attached to my motion. I believe this takes into account all of the variables and pulls them out of the correct places and enters Mr. Bailey's child support obligation. Here are the variables that I used. I'd like to mark that as the first exhibit, Your Honor. This is the chart that was in the motion. And it's a lot of math and a lot of numbers, which I hate dealing with. I've tried to make it as simple and as digestible as possible. These were the periods, the time periods in that first column going down that the special master, Your Honor, ruled child support will be modified for. In the third column, I've listed where I'm pulling the individual variables from, either the special master's finding or Your Honor's order that modified the special master. And then I've listed the new child support amount that should be entered based on those variables. So I believe I've done it all correctly. I try to make it easy for Your Honor. Mark that as the next exhibit, please. Our final motion today is mother's motion for discovery sanctions pursuant to Rule 3702. Three of the issues remaining before the court at trial are the calculation of father's child support obligation from June 15th, 2021 through May 1st, 2025. Father's ability to pay during that period, and then father's present ability to purge himself of civil contempt by paying all the arrearages that will be owed to mother. To make these determinations, Your Honor will need to see evidence of father's gross monthly income pursuant to the child support guidelines and his finances from June 15th, 2021 to present. Father's gross monthly income in the party's last parenting plan order was entered in 2016 was $21,666.66 per month. Mr. Bailey's claim is that his gross monthly income has been reduced since that time, and that is the major crux of what will be heard at trial. And mother's position is that father's intentionally reducing his income for these proceedings and is making it up elsewhere, like company credit cards, like income for stocks that he owns. The issue of Mr. Bailey failing to supplement his discovery responses prior to trial has already been heard once before Your Honor. I'd like to pass up a copy of this order. So on July 1st, 2022, Your Honor granted our client's emergency motion to continue the trial and continued the July 6, 2022 final hearing so that the court could hear each party's objections for the special master findings and, quote, so that supplemental discovery responses can be provided and both sides can be prepared. That's on the first page of this order. I'd like to mark that as the next exhibit, please, Your Honor. Now, after that, Your Honor entered another order. Pass this up to the court. In this, the order regarding motion for scheduling order, highlighted there at the bottom, Your Honor ordered that thereafter the court shall schedule a final hearing on any remaining issues and the parties shall supplement their discovery responses 30 days prior to the future final hearing date. Mark that as the next exhibit, please. That's exhibit 4. So we've had a hearing where Your Honor has ruled that supplemental discovery is relevant and necessary. And we've had a hearing and an order saying that it shall be supplemented 30 days before trial. Rule 3702, Tennessee Rules of Civil Procedure, states that if a party fails to obey an order to provide or permit discovery, the court in which the action is pending may take such orders in regard to the failure as are just, and among others, the following. A, an order that the matters regarding which the order was made or any other designated fact shall be taken to be established for the purposes of the action in accordance with the claim. B, an order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting that party from introducing designated matters in evidence. C, an order striking out pleadings or parts thereof. D, in lieu of, D is just for attorney's fees and an order of contempt. In lieu of any of the foregoing orders or in addition thereto, the court shall require the party failing to obey the order to pay reasonable attorney's fees and expenses. Rule 3703 of Tennessee Rules of Civil Procedure states that a party who without substantial justification fails to supplement or amend responses to discovery requests as required by Rule 2605 is not permitted unless such failure is harmless to use as evidence at trial, at a hearing, or on a motion any witness or information not so disclosed. In addition to or in lieu of this sanction, the court on motion may impose other appropriate sanctions, and this includes those under Rule 3702 that I just read. So the last time prior to this morning that Mr. Bailey supplemented discovery responses was on July 12th, 2022. And that wasn't even a complete supplementation. That was just tax return, 2022 pay stub, and a 2021 tax return. And the 2021 tax return was missing pages to it. Now, Father once again has failed to supplement discovery before trial. We're 2 days before, 2 days out. But this morning I received an email from Ms. Roberts' office that had, and it was an email from March of this year that was forwarded to me that had his March year-to-date pay stub and his W-2 from last year. No tax return, no information going through at least May when child support would have expired, and none of the other discovery that would be relevant in this case, like his business credit card statements that he's using to make personal expensive payments on, and no 2024 tax return, and no bank statements showing additional income, which is what we expect it'll show. So we've got the rules of civil procedure and we have your court's orders. Both of them have been ignored. And here we are 2 days before trial, again, saying we don't have what your honors ordered them to turn over. During the 5 years that this case has been pending, we've consistently made requests that discovery be supplemented. Attached to my motion are, I believe, copies of 4 different letters from different years where we've requested supplemental discovery. We've been providing supplemental discovery as we've gone along pursuant to the court order. This case has been pending since 2019. I think this is the 4th time the final hearing's been set. And we're not asking for a continuance because we've already done that once. And we're asking instead that the court impose the sanctions pursuant to Rule 3702 and 3703. We're asking that the court do any or all of the following. It'd be strike father's pleadings and award mother a default judgment, treating father's failure to obey the court order as contempt of court, imputing father's gross monthly income for child support purposes at the amount of that it was in the current order, the party's divorce. I believe that's $21,666.66 per month, and impute father with the ability to pay his court-ordered alimony and child support obligations from January 2019 to May of 2025. And that's for the civil contempt allegation that's pending against him, and impute his ability to purge himself of civil contempt and award Mrs. Bailey her reasonable attorney's fees. Thank you, Judge.
Robert?
Your Honor, this matter originated with me filing a petition to modify child support back in the last day of January of 2019. An answer was filed to that petition alleging that there was no basis for a modification. There was no, and we had also requested to terminate alimony. That became moot when the mother's remarriage. And when that was addressed with the special master to some degree also. But there was no allegation of willful underemployment in the answer. Thereafter, counsel on behalf of Ms. Tara Bailey filed a petition for civil contempt alleging 4 missed payments. That was it, just 4 missed payments in 2019. There's been no amendment filed to that petition for contempt. So we're dealing on the contempt for 4 missed payments. Your Honor, when it was referred to the special master, one of the bases in question number 2 that was referred to the master, the basis for the reduction of the petitioner's income, including any evidence of the petitioner's voluntarily underemployment, that was sent to the master and that was ruled on by the master. And the master found that there was no willful underemployment. So again, taking the master that there was no objection, the court addressed the objections that were filed in this. And the respondent's objections were, number 1, the respondent objected to the master's finding of the petitioner's 2020 gross income. The master found that Mr. Bailey's income equated to $12,684 per month, but based on his W-2, it showed a gross income of $164,350, plus other pre-tax deductions of $12,138, resulting in wages of $152 or $12,684. Respondent argues that the child support mandates the gross income. Your Honor reviewed that, found that the pre-tax deduction should have been added back in, and Your Honor set his income at 164,350, or set his income at 13,695.83. There is, we've already addressed the special master finding of willful underemployment, and it's wholly inappropriate to come back in when that was not raised in the objections, and Your Honor didn't reserve that. So again, my issue being is that in any issue, I'm going backwards with his arguments, on any sanctions for discovery, Your Honor, it has found my client's income is 13,695.83 as far as the master's concerned. That's it. We don't dispute that. That's a finding of the master. There was no appeal taken from that. And so again, there's not a dispute as to additional discovery on either part. Your Honor's found that Mrs. Bailey's income to be based on $20 an hour, and Mr. Bailey's income is 13,695. And so we took that as a finding of the court pursuant to Your Honor's order. And that's the issue. There's not as far as what his income in 2023 and 2024 are, is really not relevant to this proceeding. There's been a finding of what his income is. And so all of my issues were addressed in the special masters on the reduction. The only issue that we have to present is Your Honor did in the findings raise the issue that we objected. The special master found and assigned 0 days to Mr. Bailey. He was not awarded under the parenting plan 0 days, but because of the issue that arose in the marriage and the mother not forcing the residential time, and my client, again, not forcing residential time, Your Honor ruled that on the calculation of child support rather than on the master should be 365 and 0 rather than what it is. Now, I will point out, Your Honor, that was going to be an issue that was going to be argued, and why I do not want the motion to dismiss. We agree that all the children are now emancipated and 18 years of age, so there's no enforcement of that. But again, the parties in their marital dissolution agreement and the court order specifically stated, and they're contractually bound by the statement, that the child support shall not be modified. It's not just reduced as in the statute. It says the parties agreed, the parties acknowledge that court approval must be obtained before child support can be reduced or modified. So there is no pleading as to change the residential time. So again, I think Your Honor has to take into consideration that. But again, as far as the discovery responses are, I took it as res judicata, what your order said when it was filed on 2/12 of 2024. I did not take exception to it and ask for a reconsideration. I did not seek an interlocutory appeal, nor did the defendants in this case. And so Your Honor ruled what my client's income was, and that's what it is. So I don't think it's appropriate to come in and to ask and to relitigate the special master when it's already been adjudicated. So in our position, as far as updating discovery, that issue is done. I did not feel that there was a need to update discovery. We're not disputing that her income was set at $20 an hour, and my client's income was set at some $13,600 and some odd dollars. And I took that as the ruling of the court. Now, as far as again, their motion to dismiss our petition to enforce the residential schedule, we stipulate and agree that the children are all emancipated and have graduated high school. But again, that we filed that and we reserve that issue on the ruling of what days should be afforded to my client. But again, Your Honor ruled in your special master's report that that's what it was. And we didn't take objection to that. And so again, now the calculations of child support, his request for the introduction of child support. These are the numbers that Your Honor used, albeit that the 365 and 0 days are reflected in his, but these are the numbers that the special master found. So again, the scenario being is, I think these are the numbers. This is what the special master found. And again, once we have the hearing on Wednesday, if Your Honor takes exception to it, but again, based on the special master's finding, my client's income was set from February of 2019 until December of 2019 of $9,156, which Your Honor ruled on that he was entitled to deduct the $4,000 alimony payment. At the end of November, the then Mrs. Bailey got remarried. So again, that $4,000 was not reduced for the month of December. And so that equated his income back up. Your Honor modified her income starting in 2020 to $20 an hour. And those are the numbers Your Honor ruled after the exceptions to the special master. And I think we're all stuck with those.
Now respond more.
Anybody?
One thing, I don't have the special, I don't have Your Honor, at least I do, let me see here. One of the orders, in the order that Your Honor ruled on the parties' exceptions, one of them, and I don't have it in front of me, was the special master's finding as to a child support amount in July of 2021. The special master hearing occurred in June of 2021, and Your Honor said in the order that the special master erred in determining July of 2021 because that wasn't before him at the time. So I would argue, Judge, that everything is open since June of 2021, when we have had, Your Honor has heard the facts, or the special master's heard the facts on everything between February 2019, when this case started, and June of 2021, when we went to the special master. Everything after that is open. The proof has not been put in, and that's what we're going to do at the trial in this cause. These children, the last minor child emancipated in May of this year, so we have a finite date where evidence is going to be submitted when Your Honor needs to make a determination on child support. I would absolutely disagree that the June 2021 special master hearing established the parties' incomes all the way to May of 2025. That evidence wasn't available at the time, and now it will be.
So what was the purpose of sending them to a special master? Just to fix that one little period, and then y'all can drag it out for another 2 years, and then at that point in time, we're basically back where we are. Because what the other option is to send you back to the special master for the hearing, because of the fact that I don't do this very often. I referred it to a special master to determine those issues. Those issues were determined. We had a hearing on the exceptions, and all of that became fixed. Now it has been, my order went down in 2023, I think. It was actually February of 2024. And we're now over a year later, and the argument's being made, my order on the exceptions fixed everything as of that day. So now we're back here saying that, oh, well, we're going to reopen everything about the incomes and expenses and calculation of child support, which essentially means I'm going to be sending you back to a special master to cover all of those issues again, or else it was pointless to send you to a special master the first time. Do you understand what I'm saying?
I do, Your Honor, and I believe
We had the hearing, excuse me for interrupting. And we had the hearing immediately after the order was entered in February of that year. We could have tried to have it in July or whatever. Then it would have been a lot clearer. But now, essentially, reopening the proof to go into all of those same issues that were submitted to the master defeats the purpose of having a special master.
Yes, Your Honor, and we did not request that we go to a special master. We objected to that at the time, and it doesn't matter now, but here we are. But I agree that the special master hearing only resolved issues that only resolved the proof up through the special master hearing. I mean, it's been 3-4 years since then, and situations have changed, incomes have changed, child support, I mean, all those variables are fluid. And Your Honor can see from the different sections that were presented, the different time periods of when child support had to be determined because the variables changed between February of 2019 to June of 2021. There's like 6 different child support orders there because variables change. And so the proof, now, fortunately, I don't think there's going to be that many changes between June and 2021 now, but that proof hasn't been presented to the court yet. And that's all we have left to do. And the issue, the court still has to determine the contempt issue, civil contempt that my client filed. That issue was specifically not sent to the special master. And that would be from 2019 onward, those allegations of contempt. So that's where we are with that, Judge. 0 parenting days, that issue has been resolved, I would argue. Now, if there's been, I believe that Mr. Bailey would have the option to argue that he has since exercised parenting days to determine that calculation. But as far as the time frame goes from February of 2019 to June of 2021, I would argue that's the purpose of the special master hearing, and the exceptions and Your Honor's ruling afterward is those dates are closed. The proof during that time as to those issues are closed. Another point, something I'd point out, Judge, is that these discovery orders were entered after the special master hearing. So we came before Your Honor before and said we are going to need supplemental discovery. We're going to need to show his income for the period after the special master hearing. It's relevant. Your Honor agreed, granted our continuance, and ordered that the parties supplement discovery. That was done after the special master hearing. That was done. One of these orders is 2023 and one is 2022. That's all I have, Your Honor.
Your Honor, again, on the issue of contempt, it is not ongoing. Petition for contempt states 4 payments. 5/1 of 19, 6/1 of 19, 7/1 of 19, 8/1 of 19. That's the only issue on contempt, as to whether or not he was willfully in violation of the court's order on contempt. The special master has already ruled that he was entitled to a reduction of $4,000 on the alimony paid during that period of time. And that should have been taken out of his income. So he was entitled to a reduction during that time. There are no, Your Honor, on the issue of contempt is simply on those 4 payments. Was he willfully in contempt of court? My client was ordered to pay an amount. He paid less than what he should have paid based on our calculations based on what he was entitled to. So that's the only issue of contempt before the court, nothing past that. And again, Your Honor, it was my understanding, again, when we came before the court on the first motion to continue, it needed to be bifurcated because you wanted to hear an order. You wanted to hear the objections to the special master first and then set it for a hearing. And then after that, I asked for a continuance in the March hearing due to when I broke my leg and had to have both my leg surgery for my broken leg and my hip replacement. So that was the last continuance. But again, you know, the issue being is thereafter the court shall schedule a final hearing on the remaining issues and the parties shall supplement their discovery responses 30 days before the final hearing. There's not anything to supplement. Your Honor found that this is what my client's income was, and we don't dispute that. Again, there's not been a supplemental filing saying that he's had an addition, that there's a 15% deviation from the time that we had this hearing. So again, Your Honor, it's the convoluted time frame that we've been through causes these issues, but it's our position that parties had 3 children. My client was due a modification because of the alimony, number one, then number two, his income. The income of voluntary underemployment or willful underemployment was litigated by the special master. The special master found an amount of income. Your Honor modified that amount. And so again, that's what's owed. And we need a final determination of what's owed. But there's not a contempt on that issue, Your Honor. The issue is on the 4 payments.
Jack, you have the final say.
Thank you, Your Honor. There is a contempt on the issue in front of you, Judge, because that hasn't been ruled on by anyone. Even if he's entitled to a retroactive modification, we believe it's going to show that he still didn't pay. He still owes an arrearage. So either he violated the order that was in effect at the time by voluntarily reducing his own child support amount, or if the court gives him credit retroactively for child support modification, he still violated the order. But that's not what we're here for today. That's an argument to be made at trial because that proof hasn't been put on and Your Honor hasn't heard that yet. That's still pending. If going back to the discovery issue, if there was no discovery supplementation that was required or needed and income wasn't going to be an issue at trial, why did I receive an email this morning that had Mr. Bailey's 2023 or 2024 W-2 and his year-to-date income through March of 2025? I think they're planning on submitting that to show child support and help the court calculate child support through May of 2025. But I would argue that that is not enough supplemental discovery. That is not all of his income. And just because, the income, there's been no proof offered at the court after June of 2021. We haven't received the discovery on that, and Your Honor ordered him to turn it over. That's the bottom line. It was ordered to. The rules of civil procedure say it's got to be, and here we are. It hasn't been again. Thank you, Judge.
Well, this case has been pending for a very long time, as has been pointed out, and it's not a simple matter. And that's the reason that it was referred to a special master. The issues that were referred to the special master are set forth on page 2 of the special master's report. Those issues include the following. 1, calculation of the parties' respective incomes from January 30th, 2019 to present. 2, the basis for any reduction of the petitioner's income, including any evidence of the petitioner's voluntary underemployment. 3, whether alimony payments made by the petitioner were considered and included in the respondent's income or deducted from petitioner's income at any point. 4, calculation of child support from January 30th, 2019 to the date of respondent's remarriage, November 2019. 5, calculation of child support upon the eldest child's emancipation. 6, whether the petitioner is entitled to a retroactive modification of alimony beginning January 2019 due to a change in federal tax law. 7, whether the petitioner is entitled to a modification of child support, and if so, from what date. 8, whether the petitioner is entitled to a modification of his obligation to pay 90% of the uncovered medical expenses based on a reduction of income. 9, the total of any arrearages owed by the petitioner for alimony and/or child support. Those were the issues that were submitted to the special master. Then those issues that resulted in a special master's report being filed, and we heard on December the 19th, 2003, the exceptions to the master's report, which were filed by both parties, and the court took the matter under advisement, and I issued my ruling on February the 16th of 2024. That was filed with the court on that day. And then there was subsequently a motion to set a bifurcated hearing and some other motions that were filed. This court has recollections of this case, but it's for me to be able to say that I can rule on any of your motions sua sponte today. It behooved me to review the entirety of the file and to make a ruling but I'm not going to probably be able to do that until tomorrow or the next day. So you're set for hearing on the 5th. We will reconvene on the 5th, and I'll tell you what my ruling is on your motions, but I cannot give you a ruling. This is my first day back in Cheatham County. I've not had an opportunity. We've tried 5 jury trials in the last month, so we have not had an opportunity. I've not had an opportunity to be in my office to work on matters under advisement. So I'm going to take this file with me, and I'm going to review it tomorrow, and hopefully I'll be able to give you some definitive answers in the morning on the 5th. But I can't do any better than that. So I will take these matters under advisement. I can tell you that, as I stated, when something is referred to a special master, is to determine those issues so that the court doesn't have to have a protracted hearing on all of these issues. To then reopen because of the delay these issues defeats the purpose of having a special master involved. So one option is send you back to a special master, which I'm reluctant to do because of the delay for one thing, and because of the expense involved in it in another. I'll look at these matters and I'll try to determine the best I can what the answer will be, and then we'll come back to you on the 5th. Hopefully, if I'm able to get an answer to your motions before the 5th, I will let you know by email tomorrow. Otherwise, it will be on the morning of the 5th.
Thank you, Your Honor.
Thank you, Judge. Do I need to prepare an order for today?
I don't think it's necessary until we see what I'm going to do.
Understood. Thank you, Judge.
Melanie Tara Brooks versus Jeffrey A. Plunk. All right, this is your motion to continue the final hearing that's set for tomorrow.
Yes, sir.
I'll hear your motion.
Okay. Judge, this matter has been pending since October of 2023. However, since that time, there's been a lot of moving pieces and a lot of things have changed. And but specifically for tomorrow, I have had an issue with receiving pleadings, amongst other things, from opposing counsel's office. I am not here to say that anything was done purposefully. I just know that I represented Mr. Plunk back when we did this back in 2016 and 2017, and there were the same issues. I have repeatedly asked Ms. Myers to send me things via email, since apparently there's something wrong with my office getting US mail from her office. And in any event, despite what the certificate of services say about the dates that things were sent to me, I oftentimes either did not receive them until much later or did not receive them at all. I have gotten to know the clerks in the clerk and master's office very well, and they are very kind I get the pleadings from them because I can't get them from Ms. Myers. But in any event, on Wednesday, July 30th, I received a motion to set for final hearing. And that hearing was set for Monday, August the 4th. The certificate of service says that it was mailed to my office on July 18th, but I did not receive it until July 30th. I immediately reached out to Ms. Myers and said, your certificate of service says this. I am just now getting it. I am not available, with 2 business days notice, to be up here. But what was interesting, Your Honor, is throughout the entire month of July of 2025, she and I were in constant communication about trying to settle this matter and all of these other things. Never once was it mentioned. In any event, she told me that she would reset her motion. And I told her, that's great, just send me some dates. And then in part of the email correspondence, I said, in the future, can you please check with me prior to setting anything, just to make sure that those dates I'm available and can be here. And can you also email me things? So I get Ms. Myers told me that she would obtain dates from the court. And it was my assumption, because what I was asking her was to reset her motion to set for final hearing. She sends me, I believe it was an email, and she said the court has these dates. So I said, November 4th, I can be there November 4th. But again, it was my assumption, because that's what we had discussed, was her resetting her motion to set. So, in any event, she sent, a proposed agreed order to me via email. And it was only then that I realized, oh, she didn't reset her motion to set. She set it for final hearing on November 4th. And so I emailed her and said, because she was asking me if she could sign my name with permission to the agreed order. I told her, hey, we need to talk, because I was under the impression this was the date that you were resetting your motion, like that it was not set for final hearing. I did not receive a response, and it wasn't until mid-October that I reached out to Miss Myers and said, are you still going forward on your motion to set on November 4th? Excuse me, let me back up. Yes, I asked her if her motion was still set for November 4th. She didn't respond, so I contacted the clerk and I said, can you please send me a copy of, was there an agreed order that was filed sometime around this time? And so the clerk was kind enough to, because prior to this, that entire week leading up to this, I had been emailing and texting and trying to call Miss Myers saying, we need to resolve this. We need to resolve this. We can simply do an agreed order. We have not finished discovery. We have not been to mediation. We have not done all of these things. She would not, we could not reach an agreement. And so what I did was, that's when I filed this emergency motion. And then unfortunately, Ms. Myers, I think, was out of town for the 2 weeks after that. And so we weren't able to get a whole lot accomplished. However, the clerk's office did send us some final hearing dates to both of us, along with an email that said, Judge Wolf has reviewed it. The soonest he can hear it is, because I was scared. I was nervous going forward with this motion on November 3rd, with the final hearing being tomorrow, because I'm not prepared. And so it's okay. Miss Jennifer in your office, and forgive me, I don't mean that really, I just can't recall her last name off the top of my head. She told us to contact Miss Rhonda, and we got dates. I sent them to Miss Myers, never heard back, never heard back, never heard back. And so, Judge, I am just here to ask you to continue this matter to a date that is convenient for all of us. And Judge, I'm also asking for my attorney's fees today, because we simply could have resolved this with an agreed order. Even this morning, I was running a few minutes late because traffic was behind. So I was reaching out to your office to let you know that I was just a few minutes late. And even then, Ms. Myers said that she had no idea that the motion was set for today. She thought the motion was set for tomorrow, even though your office, the clerk's office, everyone had emailed her that it was taking place today. So in any event.
So what you're saying is, what we have here is a failure to communicate.
Right, but Judge, it's not, well, I'm not quite sure what's going on her end. I cannot surmise. And again, I'm not here to say,
Well, the fact though is you're not ready for a final hearing and you did not understand tomorrow was the final hearing.
correct, until much, much later. Yes, sir. And, Judge, so here we are. I have attempted, to communicate I will tell you the biggest probably piece of the puzzle is, the parties only have one minor child remaining. And, he, contrary to the parenting plan that was entered in 2017 by agreement, he has left my client's home and refused to return. The child is 17. He is unruly. And so against the court order, Ms. Meyer's client is not sending the child or forcing the child to go. And which is, that's fine. However, now we're dealing with the issue that, her client now wants retroactive child support to the date that he moved back in to mom's home, contrary to the court order. So now that I've learned that, I'm going to have to do a lot of discovery. A similar thing happened, prior to the, party's oldest child emancipating. We entered an order in 2017, and the daughter was 17 years old at that time. And so we put a provision in the parenting plan that due to her age and maturity level, that she was under no obligation to, adhere to the parenting schedule, laid out. And so, but we still gave Ms. Meyer's client credit for 182.5 days for both children. However, the child never returned to her mother's home. And so if their position is now, which is not what is in their initial, petition that she filed, that petition has not been amended. However, if her client is now going to be seeking retroactive child support back to the date that the child unlawfully stayed at her client's house, then we're going to have to go back to 2017, 2018. I'm going to have to file a counter petition that says then my client wants that money from that time as well, when the daughter did not, visit with the mother, even though she was given credit, which is the same exact argument that her client is now using with the son. So, and I will say that it does not prejudice her client at all, to reset the hearing, because she is in physical possession of the child. And she's also now, we entered into an agreed order to where my client is now paying child support based on the client being in her home full time. So it's not going to prejudice her at all. But it would, very much so prejudice my client if we were to go forward tomorrow. Thank you, Judge.
Your Honor, this is the first time in 23 years that I've been accused by a counsel of not sending out documents like I stated in my certificate of service. She did ask me to email her. I did email her. I've got the emails here. After she sent me an email claiming that my motion to set was rescheduled, I contacted her when she asked that I reset my motion to set. I contacted her, verbally spoke to her. She agreed that there was no reason for us to come on a motion to set. We could agree to the date of the final hearing. I then prepared an agreed order, sent it to her. I've got emails to show to the court. Twice I sent it to her before the court date on my motion to set. Both times she did not respond whatsoever. So where she claims she doesn't get my mail, she obviously also doesn't get my emails. So I sent it to her on 2 occasions saying we're setting the final hearing for November 4th, per our verbal conversation, and did not hear back from her. I then came before the court on my motion to set and set it on the date we had agreed to. Then Yes, she has reached out to me several times about setting, entering an agreed order as to resolution of this case. My client has not agreed. I've made offers. She's made offers. There has been no resolution. That is not the fault of my client. That's not the fault of her client. There just isn't a resolution. We're going to need the court to assist in this. As far as setting tomorrow, she's asking to reset it because there hasn't been discovery done. My petition was filed on October 5th, 2023. That is over 24 months ago that they had the opportunity to give us discovery and ask for these things. The proof, they've argued the case. I'm not trying to argue the case, but the fact is, father kicked the child out, sent my client a text and told him that he was coming to live with her. So he did come to live with her almost 2 years ago, a year and a half ago. This child will be 18 in January. We had to come to court and file a petition to set child support because he refused to pay anything for this child in that amount of time. He's only paid a few months worth of child support. We contend that they agreed to this date and that the only issue that's going to be when the court continues, and I recognize the court's going to continue it, but that the only issue remaining is what child support he owes for all this time, because the child's going to be 18 years of age. She contends that she agreed to a date. She wants to set it off till March. This case hasn't been heard by any other judges, and there's no reason to put this case off another 6 months when it has already been over 2 years. So we understand the court's going to give us a new date, but we're asking that it not be 6 months from now. Thank you.
Well, I think at least what we have here is confusion or lack of agreement on what was taking place tomorrow. And frankly, the local rules do require mediation or waiver of mediation, and Judge Lockhart Mash apparently signed your order to set the case in front of me, but there was no indication of having waived the requirement of mediation by this court. It doesn't sound like from what Ms. Myers is saying that mediation would likely be successful in this case. I'm going to grant the continuance, but I'm not going to reset it for March. I think it can be reset more quickly than that. So what dates do you have available?
And Judge, if I may just respond to that, I was sent, I think 5 or 6 dates by your office, and that was just the first one I was available for. It wasn't, I didn't ask for it.
So you don't have any availability until March?
No, sir. On those specific dates that she was sent to me. Absolutely, I have availability before then. The only thing I would request is just time for, I personally do believe mediation might be successful.
I've got some dates in January. We're in the beginning of November. That would give you ample time to get your.
Absolutely. And just with the understanding that because I will have discovery to Ms. Myers by the end of this week, by the middle of this week.
January 8th, 9th.
I'm sorry, I'm on the wrong month.
Both those dates are available for me, Your Honor. Your Honor, I don't have discovery even today, so if they wanted discovery, they could give it any day.
I'm sorry, ma'am.
Half a day.
I think it's gonna be a full day.
I don't see why. We've got 1 month. So this child will be 18 when we come to court.
No,
Sorry
in a-
about that.
In a year.
We're gonna be talking incomes.
January 29th.
Hang on, Judge, I'm sorry.
I can do all 4 of those dates.
Did you say-
29th, 28th, or 29th.
28, 29 is what you said, I'm sorry.
January.
Okay, I'm sorry, trying to. 29 would be great for me.
29th.
And will that start at 9 a.m., Judge?
Pardon?
Start at 9 a.m.? Okay, and it will be here? Okay.
All right. I'm granting your motion to continue. The case is reset for January 29th. I expect counsel will agree on whatever discovery so that you can get that completed in the next 30 days.
Yes, sir.
or so. All right, we stand adjourned.
Thank you, Judge.
Okay, so the second case I want to talk about first. It seems to me that the issues aren't with the other attorney's office. The issues are with this attorney's office, the attorney that brought the motion. Because when someone mails you something and they have a certificate of service, it means that they've been served with those documents. So those documents are somewhere in her office, but whoever received them either didn't know what to do with them or did the wrong thing with them. That's not on the other attorney. And then she asked him to be emailed, and they'd been emailing back and forth before, and then all of a sudden she doesn't get the emails. So it sounds to me like she's using this to postpone and postpone because she's not ready. That's just my opinion. Now, the first case, it seems also to me that when Mom remarried, her alimony went away. And when her alimony went away, she said, oh my gosh, we need to redo his calcs and make sure that he was paying me the right amount in support. The only thing is, did they include that $4,000, which is pretty substantial alimony, in my opinion? It would be for me. But if they included that $4,000 as income for her and decreased that $4,000 of his income, and that's what his attorney was speaking about. I have a feeling that when they redo these calculations, Mom's really not going to get that much more, if anything more, because supposedly Mom's attorney says Dad missed 4 payments. Well, he didn't really. He just paid less, and the reason he paid less is because she wasn't being imputed with the $4,000 as income. And he wasn't having it decreased in his income. Or maybe it was decreased in his, but it wasn't considered as an income for her. So, yeah, it's some stuff they've got to figure out, but I have a feeling it's not going to amount to a whole lot for her. And she's expecting a windfall. So, anyway, thank you guys so much for watching, and I'll see you another time.